So here's the thing about trusts. They're private, and that's great until no one knows where the trust actually is. Maybe your parent passed away and no one can find the documents. Or maybe they worked with an attorney years ago and have no memory of who it was. So what now? Is the trust still valid? Can you move forward without it? In this video, we'll show you how to track down a missing trust, what alternatives exist if the original can't be found, and when is a copy good enough. And if you want more real-world estate planning advice, click below to join our newsletter. We share helpful updates for California families every month. Okay, so trusts are private. This means there's no online depository for trusts, and no one is entitled to look at your trust until it's not great. So your parents may have worked with an attorney a long time ago and they don't remember who did their trust, or maybe your parent has passed away and you have no record of the trust. How do you know if your parents created a trust in the first place? Well, if they owned a house, the first place to look is on the grant deed. Estate planning attorneys who prepare an original trust just about always prepare a deed to transfer the residence into the trust. If the deed says that the residence is titled in the trust, you know that a trust likely exists. Here's an example of a recorded deed. You can see that the house is titled in the name of the trust. Also, if your parents owned brokerage accounts, they hopefully titled those accounts in the name of the trust. If you're looking at their bank statement and it says name, trustee, that means a trust is involved. So here's a sample bank statement. You can see where the name of the trust is included. So how do you find a copy of your trust? The easiest way is usually to identify the attorney who drafted the trust. Sometimes the attorney's name is listed on other documents you might have, like a power of attorney. Again, you should look at the grant deed transferring your residence into the trust. When you originally create a trust, attorneys draft that deed transferring the house, if you own one, into the trust, and they usually put their name at the top left-hand corner of that deed. So pull the deed for your house and you might find the attorney's name there. Then you should reach out to that attorney. Attorneys are required to keep files for their old clients. If they're retiring, it's common for them to send a letter to you and let you know who's taking over your file, and they'll pass along those files to that attorney who takes over their caseload.
Did you know my mom has a monthly newsletter where she shares helpful information? Click below to join.
You can also ask your new attorney to call the old attorney and have them send PDF copies of your original documents to the new attorney. Usually the new attorney doesn't need the full hard copy file, and it's pretty dusty too. Sometimes you'll need to sign a release form showing that you consent to the old attorney sending your file to the new attorney. But what if the old attorney doesn't have your file? Or the old attorney died suddenly and no one knows where their files went? Sometimes your new attorney can reach out to their county bar association, which can send around an email to other members asking if anyone has the estate planning for the person that you're looking for. Now, another question that comes up a lot is whether you need the original wet signed ink trust. You usually don't need this if you're doing a restatement and amendment of your trust, or if you're administering a trust, or if you're dealing with banks, or doing real estate transactions. The only time you'll actually need the original trust is if that trust is being contested in court. If someone's claiming that the trust is invalid, or there was undue influence or fraud, it's really helpful to have the original trust. But this is so unlikely to happen. So in most cases, if you just have a copy of the trust, that's just fine. But you do need to keep the original wet signed will. In California, Probate Code Section 8200 says you're required to lodge the original will with the county clerk in the county where the deceased person lived within 30 days after their death. You also need to send in $50 and they'll mail back the first page of the will with a stamp showing the entire will was lodged. They won't take a copy in order to do this. Now, personally, I think this is an antiquated and annoying requirement in the probate code that probably originated a long time ago and is not needed anymore, but it's still on the books and you're still required to do this when the testator passes away. Also, the probate code says there's a $500 penalty for not lodging an original will but I've never seen this penalty imposed on anyone. So yes, a copy of a trust is often enough to get things done, especially if there's no dispute. But when it comes to the original will, that's a different story. California law still requires you to lodge it in court. Do you need help navigating this process? Subscribe to the channel or visit our website to connect with our team. We're here to help.
If this video is helpful for you, share it to someone else who might benefit from it.